Hi there, I'm Ron Wright. I teach criminal law and criminal procedure classes at Wake Forest University. Today we're going to be talking about some of the constitutional rules that prevent the police from using physical coercion, like torture, or other forms of coercion when they're interrogating a suspect, when they're questioning a suspect who is in custody. The case that really got all of this started and made it into a constitutional issue is called Brown versus Mississippi from 1936. So we'll be talking about Brown and then the cases that flow from Brown versus Mississippi. So let's go in and talk. Okay, folks, let's get started. We're going to be talking today about remedies. What happens if the police violate one of the rules of the road, one of the requirements that they have to follow when they're collecting evidence? What happens if they violate one of those rules and they obtain evidence? Under the law, the constitutional law of the United States, we say that that evidence has to be excluded. We call it the exclusionary rule. So we're going to be talking today about the moment in the middle of the 20th century when that rule became the national rule. Let me back up first and mention that the exclusionary rule first showed up in U.S. law as a really fully formed concept in a federal case, United States versus Weeks from 1914. But that just applied to crimes that were prosecuted in federal courts, which were not that many crimes at that point. It was a tiny little system, and most of the action then and now is in the state courts. So Weeks established the concept, but at that point the courts were focusing not so much on what this would do for the police, how it might change their behavior. Instead, it was more of a judicial integrity concept. It was an idea that we as judges need to have clean hands. We need not to be involved in ill-gotten gains, that is the evidence that the police obtained by breaking the rules. So judicial integrity was the main rationale at that point. But I want to focus on two further points along the way on the timeline. One point was 1949, when the U.S. Supreme Court decided Wolfe versus Colorado. And at that point they say, the requirements of the Fourth Amendment apply not only to federal law enforcement officers, but they are a constitutional requirement that apply to all state, local, all government actors at all levels. They are incorporated against the states through the Due Process Clause. And so the Fourth Amendment rights are now imposed on all state actors. But they said, not the remedy. The remedy, the exclusionary rule, as I mentioned in the federal courts, we're going to keep that just a federal concept, and we'll leave it to the state courts to decide what remedy to impose if their state actors violate these Fourth Amendment requirements that are now being imposed on them for the first time. It's between 1949 and 1961, there's this period then when the states are in charge of the remedy. And right in the middle of that, 1955, there's a case, People versus Kahan. I think it's an interesting case for you to take a look at as an example of the judicial reasoning in this setting. So we'll use that as a point of discussion along the way here. And we'll use the discussion from the court in the 1961 case of Mapp versus Ohio, when the court finally came in and said, okay, experiment over. We're not going to allow states to create their own remedies. Instead, we're going to create one national remedy. Everywhere now it will be the exclusionary rule as the remedy if the police violate any of the search and seizure requirements that were imposed on them in 1949 in the Wolfe case. So that's where we are. Let me tell you first of all about the facts in Mapp versus Ohio. Really colorful story. There's a police officer in Cleveland who is investigating possible illegal gambling, connected very often with sports like boxing, but also numbers running, a sort of illegal version of a lottery. And there's a person suspected of being involved in some of this activity, Don King, who later became a famous fight promoter. You may have seen him, the guy with the sort of spiky hair. And so Don King, his house is bombed. And so he calls the police and he says, hey, somebody bombed my house, and I think I know who did it. So they started investigating the bombing, and they believe that it's that the fellow who did it, Virgil, I'm forgetting Virgil's last name, but anyway, they believe that Virgil was hanging out at the house of Dalray Mapp. She is at the time involved with a heavyweight boxing contender, Jimmy Bivens, and she's always interacting with the police. She's very savvy, knows what they can and can't do. And so the police show up to her house and they say, "Ms. Mapp, we want to search your house." And she says, "No, you can't search my house." And then she gets on the phone with her attorney and says, "The police are here." And he says, "I'm coming over right now, but don't let them in." And so 3 hours pass by. The original 4 officers are still there waiting. 3 more officers show up and they say, "Heck with this, we're not going to wait anymore." And so they just bust in. They tear open the screen of the door. They break the glass of the door. They reach inside, open the door, and come in, completely illegal. And then, Dalray Mapp comes charging down the steps. She lives on the 2nd floor. She comes charging down the steps and says, "Where's your warrant?" And she said, and they wave a piece of paper at her and say, "Here's our warrant." She grabs the paper from them, and as the opinion puts it, she hides it in her bosom. I guess she stuffs it down. Turns out she was wearing a turtleneck sweater that day, so somehow she hides the paper from the officers there because she wants to keep it and inspect it later. The opinion delicately puts it this way: they recovered the warrant from her. We don't know how that happened, but they recovered the warrant from her. And they go upstairs and they pretty methodically search the house. They search her bedroom, her daughter's bedroom, the bathroom, the living room. They ultimately go down to the basement and look through the basement area, including some storage trunks. They're looking for Virgil, the suspect in the bombing, but they're also looking for betting slips, little bits of paper that might be evidence of her involvement in an illegal gambling operation. And ultimately, they don't find betting slips and they don't find Virgil, but they do find pornography. They find magazines and pornographic books, and so there's a prosecution for pornography, for violating the obscenity laws. And her claim is you can't use the magazines and books that you found because you obtained them illegally. You broke my door and you didn't have a proper paperwork, and so you can't use it. The Supreme Court ultimately agrees, ultimately says that, yeah, you're right. This is, even though it's a prosecution in state court, in the Ohio state courts, and even though up until now we have said that we'll leave the remedy to the states, we now think we're going to impose the exclusionary rule as a necessary part of the package. It's just part of the Fourth Amendment package of rights and remedies that go together. So that's their conclusion here. I want us to go through a thought experiment. Imagine, first of all, that the year is 1955. So reel the clock back, not 1961 in Ohio, Mapp versus Ohio. Go back 6 years earlier. You're in California in 1955 arguing the case, People versus Kahan. At this point, states have their choice about what kind of remedy to impose. If you are arguing for the ACLU, the American Civil Liberties Union, you're arguing for this new exclusionary rule, you're asking the California Supreme Court to impose it, what would be your arguments? First of all, I think you'd talk about deterrence. We need to alter the behavior of police departments. We need to change the way officers do searches. We need to give them an incentive to follow the law. And you might say, look, it's pretty clear that whatever regime is out there, maybe civil damages, make the department pay money or something like that, that's just not working because look how many violations we're having, and we need some bigger guns, some bigger deterrence force to convince the police to follow these rules. And you would also raise an argument, I think, along the lines of judicial integrity, as I mentioned, involving the People versus, or the U.S. versus Weeks in 1914, the idea that the judges need to keep clean hands. Over on the other side, on the prosecution side, in California, in 1955, how would you reply? Well, you might say, look, I don't know that those possible benefits of a new exclusionary rule are really going to get you all that much, because we do have alternatives. You could just beef up the alternatives and make that civil suit more effective. And really, police officers care more about money than convictions. So if you really want to change their behavior, change the way they have to pay out money when they violate the law. And in terms of integrity, well, judges in civil suits don't really ask where did this evidence come from. They don't ask whether the parties have clean hands as they bring the evidence in. They just receive the evidence and evaluate it, and they evaluate it for its truthfulness. So as a prosecutor in 1955, I might say judicial integrity is best served by having a truth-finding process and just focus on whether the evidence is accurate or not whether it was obtained following the rules. So that's, I think, the nature of the argument that you would have on both sides. Oh, also the prosecutor would say not only are the benefits of exclusion maybe not as great as the ACLU suggests, but also there are serious costs of this kind of exclusionary rule. We're going to lose convictions that would have been based on accurate information. It's going to slow down criminal cases. You're going to have to stop and have motions to suppress that are resolved before the case can go to trial. And I'll give you a famous quote from Justice Cardozo in 1926. There is no blinking the consequences. The criminal is to go free because the constable has blundered. The pettiest peace officer would have it in his power through overzeal or indiscretion to confer immunity upon an offender for crimes the most flagitious. There's Cardozo for you. Always finds a new word for us to scramble to our thesaurus and look up. But that's the general gist of the arguments that the parties would put forward in 1955 to a state court. Now, how do those arguments change as we move 6 years later into the Supreme Court? What difference does it make to the arguments when you shift from the state forum to the federal forum? Well, one thing that it does on the prosecution side is you can not only argue the whole costs and benefits of exclusion calculus, but you can also say, you know, federalism also should weigh on our side of the scale here. The federal government should be pretty reluctant to get involved and tell the states how they should be running their operations. So a little bit of respect for state independence and state comity should figure into your decision here. And you might say at the federal level, we're talking about enforcing the due process clause, a very general phrase, and the idea that there's a specific remedy for violations built somehow into the due process clause that's reaching out and grabbing the Fourth Amendment and implying that against the states. It's a pretty general standard to result in this specific remedy. So there's a constitutional interpretation style argument involved for the prosecution in 1961. And over on the defendant's side, the ACLU in 1961 in federal court, I think they would emphasize national uniformity. You know, there is one Fourth Amendment, it's supposed to apply to everyone. We shouldn't have something that looks dramatically different for people in California than for people in Ohio. And because all the rights are the same, rights and remedies are inextricably linked. And so the remedies should be the same everywhere since the rights are already the same everywhere. So that would be the nature of the argument as it shifts from a state forum to a federal forum. Over the years, we have learned something about the real costs of this rule. They're not trivial, they're not huge either, but we do know that somewhere between 2 and 4% of all felony charges are lost because of search and seizure problems, because of the exclusionary rule. We also know that prosecutors refuse to go forward with a pretty substantial number of cases. It's harder to get an estimate on this, but I think it's reasonable to assume that there's at least as many, you know, it at least doubles the number of lost cases if you take into account the cases that the prosecutor's not even willing to file because they know it's just a loser in Fourth Amendment terms. So there's some cost. On the other hand, it's not like we're losing half the cases. We're losing something between 2 and 4% of the felony charges, and let's say another, I don't know, 4 or 5% of the charges that the prosecutors might have filed but did not. When we get together next, we'll be talking about how those benefits and costs of exclusion play out in today's court system. And we'll also be comparing what we do in the United States to the different forms of exclusion that happen in other countries, where in some places anyway there are exclusionary rules, but they're applied in a somewhat less categorical way, more of a loose balancing set of interests that produce somewhat less predictable outcomes, but perhaps also less costly outcomes. So we'll be talking about that next time.